Sometimes you are in the wrong place at the wrong time. Tina Fey is an actor who has been on, she used to be on SNL, and she had her own show called 30 Rock. And when Tina Fey was 5 years old, a random stranger walked up to her and slashed her face. You can see her scar in every single thing that she's ever done. The scar is literally on her face. It's like right around here under her mouth. And sometimes random acts of violence happen. And that sucks. And that's the world that we live in. A recent workers' compensation case involves a random act of violence. And it sucks and it's yucky. And the result is unfortunate for the victim here. But the law is the law, and we're going to analyze it. And you know what? It's up to you and me to decide whether or not we agree with it. The claimant worked as a rental car manager. So the way that the business operated, he worked out of a hotel. There was a kiosk in the hotel where where customers would come up and rent the car. Every single night before the claimant would go home, he would take all of the rental car agreements and he would walk them from the kiosk inside the hotel to an outside office about 50 yards away from the hotel. On June 28th, 2019, the claimant was walking in between the hotel and the rental car office where a random person walked up to the claimant and shot the claimant 7 times. The claimant suffered terrible injuries. I'm going to read directly from the case. A surveillance video captured the shooting. The video showed that the shooter emerged from an unknown location, entered the courtyard where the claimant was walking, shot the claimant, and turned to leave. The shooter then turned back and shot the claimant several more times before fleeing. The shooter did not attempt to rob the claimant or take anything from him. The shooter's face was not clearly visible on the video. The claimant sustained injuries to his left hand, left leg, right arm, intestines, stomach, and brain. He suffered several strokes, lost his right kidney, and part of his vision. So this shooter gruesomely injured the claimant. There's no doubt about that. We don't know who the killer was. We don't know who the shooter was. All he did was go up to the claimant and shoot him and then flee. This shooter did not rob the claimant. This shooter did not steal any rental cars. This shooter just committed a random act of violence. And this is why this case went so far in litigation. The motive behind the shooting was completely unknown. At the trial level, the claimant brought forth an expert to establish that the area around the hotel was dangerous. More specifically, there's some evidence of vandalism and some evidence of stealing cars at this specific rental car place. Of course, the employer brought forth an expert to establish the opposite. But one thing is true. The shooter didn't steal anything. The shooter just walked up to him and shot him. At the trial level, the judge granted compensability. The judge said that this shooting was probably work-related. This shooter probably was targeting the manager, the claimant, and because of that, we're going to grant compensability. The employer appealed that decision, basically arguing that there's no causation here. And I want to dive into what that means. So in workers' compensation, in order for an accident to be compensable, or in English, in order for you to get medical treatment through your employer's workers' compensation benefits or insurer, you have to establish that the accident took place during the course and scope of your employment and arose under the employment itself. So course and scope just means you were working while this happened. Like, there's no doubt about that. You know, you were clocked in. You were at the office. You have to establish course and scope. You also have to establish arising under. Now, arising under your employment means that there needs to be some sort of occupational causation. Now, here's where everything gets a little bit squirrely. So let's see what this case says about this exact situation's causation. It's very interesting. Here, there are no competing causes to assess. Although the identity and motive of the shooter are unknown, the cause of the claimant's injuries is known. He was shot 7 times at close range by an unidentified assailant. There was no evidence of any other cause. Being shot was the one and only cause of the claimant's injuries. There were no competing causes, and the employer did not trigger the major contributing cause analysis by claiming the shooting was personal in nature. Rather, the employer had no burden to prove a lack of occupational causation or offer evidence of competing cause. The claimant never established occupational causation in the first instance. So the appellate court is saying that this shooting was too far removed from the work itself. Let's say that you're on a walk, on a break. Like you're literally like, yeah, sure, you're at work, and maybe you're even clocked out, but you're just like on a walk on a place where people normally take walks where you work. If you trip and fall and you injure your arm, the causation was tripping and falling while you were on break, which has to do with your job. But getting shot from an outside third-party tortfeasor has nothing to do at all with your job in this exact situation. And I think that speaks to school shootings. Like if someone walks into a school and you cannot establish any sort of motive whatsoever other than like shooting individual people, then I guess it would be difficult to establish workers' compensation. But I just feel like that honestly is just such a unrealistic situation. Like those school shootings are terrible and evil to even think about. But it's not evil to think about, but you know what I'm saying. They're awful. But usually at schools, they're gonna get apprehended in some sort of way. Like, I don't know how many, I haven't, looked this up, but I mean, how many have just like gotten away and been completely unidentified? I just feel like it's kind of not realistic. But moving on, getting back to this, the appellate court said that this shooter had nothing to do with his job. This shooter, which by the way was the causation of him getting injured, literally had zero occupational causation. It did not relate to his job whatsoever. So the appellate court decided that the accident was not compensable, and even though the employer never provided any workers' compensation benefits, the employer denied the workers' compensation benefits from the start. The employer essentially, the appellate court essentially agreed with the employer by saying, "You're right, there is no occupational causation." In the appellate court's reasoning, they went through a ton of different cases, many of which had third-party tortfeasors that committed torts, and the accident was considered compensable. An example of this is Struther. In Struther, the injuries resulted from a physical attack where a cashier was robbed by assailants who targeted her based on knowledge that she carried cash deposits for her employer. So people came up and robbed and attacked a worker because the robbers knew that the claimant had work-related money on her. Another example is an employee was struck by a car driven by a coworker's jealous boyfriend while the employee collected shopping carts for his employer in the grocery store parking lot. Now, in that situation, there was sort of a love issue where the boyfriend of a separate employee killed the claimant because the claimant was apparently sexually harassing his coworker. Now, you might be thinking to yourself, what does that have to do with their job? Where's the causation in that situation? I'm going to read from that exact case. Some jobs are more prone to workplace accidents than others. Usually this is so because one or both of the following factors: the nature of the job, dangerous duties, and nature of the environment of the job, i.e. dangerous locations. In this case, it was the environment. The decedent was collecting shopping carts at night. Obviously, an employee being hit by a car in the customer parking lot while collecting shopping carts at night is a risk incident to the hazards of industry. Additionally, while the decedent had no apprehension of personal animosity of a coworker's jealous boyfriend, there's no question the genesis for the dispute giving rise to the fatal injuries here was in the workplace. The instant case is analogous to Tampa Maid, where a love triangle among 3 coworkers resulted in claimant being assaulted with a shrimp knife. Specifically, both there and here, it was the interaction of people connected only by the workplace that prompted the accident, and therefore we reach the same conclusion of compensability. In English, what that means is if you met at work and you get into a fight, that fight is probably compensable. And I know that I'm generalizing, but I think that's super interesting how, even though, obviously a love triangle or a love quarrel probably has nothing to do, or likely has nothing to do with the job itself, unless you're working at a strip club or something, that would be a really weird set of facts. Anyway, getting back to the main case that we're looking at, in this situation, we don't know the motives of the shooter. Was the shooter a prior employer, or was the shooter a prior employee who was fired? Was the shooter someone who's been stalking the rental car agency to try to get a free car? We will never know. We maybe one day we'll know, but as it stands right now, December 28th, 2023, we have no idea. So the appellate court decided that the injuries were not compensable, and I believe that rehearing was denied. So I thought that was interesting. When it comes to third-party tortfeasors, you have to look at the genesis of the relationship, of how that third-party tortfeasor is connected to the to the employer or the employee. And you also have to look at the motives of that employee. Now, when it comes to school shootings, I just want to bring this up because I saw a really interesting article about a Virginia teacher was shot by a 6-year-old. She can proceed with a $40 million lawsuit. Quick side quest in this YouTube video. Workers' compensation provides businesses immunity. So if a worker gets injured at work, that worker can't sue the employer. The worker has to go after the workers' compensation insurance. And yes, I'm generalizing here, and there's a lot of exceptions, but nonetheless, it made me think. Okay, yeah, a 6-year-old shooting a teacher, I guess it is technically a school shooting, and in Virginia, the court decided that it was not a work accident. And I just thought that was really interesting because, how would that play out in Florida? If a student shoots a teacher, does it matter why? Because the genesis of the relationship there is student-teacher. I don't know. It's interesting to think about. All right, friends, I'm out. I love you. Peace.